do that.
Our intention is only, please, there should not be any repetition, and to the extent you can directly come to the point and explain.
Well, we'll modulate in such a way that we don't repeat it.
All right.
Well, not where,
I have
because
requested
he-
for a longer time for the reason that the
Right.
first
Yeah.
person may have to read all, my lord, relevant judgments from Sirur Mat till Adi Shiva.
Yes,
Because that will have to be present.
if the first one read out the judgment, then
Then
others
will
need
be
not.
Perhaps not.
Others can only simply refer.
the
to
others will only refer, my lord, to the paragraphs, relevant paragraphs, we will not repeat it. But, my lord, to make our submissions, we may have to refer to them, my lord. We, for example, my lord, see, just a moment, sir.
You can keep the relevant lines on your piece of paper.
We'll have that. We are having that.
And you need not to force us to open the paper book. and
No.
This create problem.
That's
When you
correct.
come then please come to page number 1407,
Opening
1000
the papers.
then creates
No,
problem.
we will not do that. We will
We
not.
can assure you, we will read those pages.
We will not do.
If we are
We
not
will.
read already. Otherwise, you just keep on referring to, we will note down and read.
That's correct, my lord. That's all what we are.
In our written submission, we have extracted.
Lord, what I have done is, only a minute. Lord, what I have done is, my written submissions might be 90 pages because the relevant paragraphs I have extracted so that your lordship may not have to volume 7 and volume
We have
8
seen
point
that.
C, etc.
We have seen that part. Some of the paragraphs are reproduced. That's why we are saying, please don't force us to go to volume number so and so, SCC so and so.
No, we will not.
Number
We
We have extracted.
That will create problem.
Your lordships,
Yes, Mr. Dev.
What your lordship says about precision is certainly something all advocates should do at all times. When I have practiced the law abroad, we get up and say, we have 5 points to make. I will argue these 3, somebody else will argue 2. That
Exactly.
is the way to do it. As far as referring to things are concerned, we have put the relevant paragraphs in our submissions themselves
Precisely.
Not surely be entitled to.
what the learned solicitor has said. My lord, your lordships will be rewriting or rather re-examining Article 25 and Article 26. Now, I have no doubt your lordships will read every word. But if your lordship is satisfied that your lordship wants to hear more, then kindly bear that in mind.
Certainly.
That's all I want to say, because this subject is one of immense importance.
Dr. Rajiv, then you are absolutely right. If we get up from here and we are not sure about that, what we have really understood from both the entire perspective, then probably we will be also lacking in forming an opinion.
I have argued before several benches.
Lord, one fact,
Argued in February that it would end in March. It actually ended in September because of the issues involved.
it will not,
one factor.
It will not be as bad as that.
Very, very relevant.
it will not be as bad as that.
That will be a very discouraging.
Will not see.
Lord, may I just make
Factor
a single
may be
comment?
kept in mind, which would, my lord, curtail the time also. Your lordships have been very clear in the reference and your lordship's order, which my lords just now were pleased to read, that your lordships would be answering questions referred. So individual facts, etc., are not to be gone into. Some of us, my lord, have also gone into issues like personal law, Appu Mali, Narsu Appa Mali, etc., which is not even remotely concerned. Some of us have gone into right of educational institutions, minority. We are concerned with 25, 26, and what should be the scope of judicial review in
Maybe
interpreting
beyond
religious.
25, maybe beyond 25, 26, there are some other provisions also referred to like Justice Censud has relied.
There are 14,
Chapter 15, yes.
Reference to Article 13 also.
Some judgments have referred to Article 17.
Lord,
My lord, either to say that affirming something or to say that it is irrelevant, we may have to refer to something.
This I need only half a minute from you. I try to that broadly categorize because that might help you and it will help us also. One category of the lawyers will be arguing will be broad discretion given to the court to enter into any domain of fundamental right that has been encapsulated into the Constitution of India. That is one broad category of lawyers. Secondly, court has no such discretion in religious matters, even if it pertains to constitutional morality. That will be one group of the lawyers will be arguing. The third will be the discretion accorded to the court to interfere into religious practices is narrow, but some minorities may be insulated. That is also, we could see that argument coming
Which is
forth.
not the subject, question frame.
And one group appears to be arguing that the court may interfere, but only on a case-to-case basis. That is where the facts are being referred to, relied upon. Now, if this is the kind of broad category, then one set of lawyers who want to argue, say, on point one, they can argue one after the other, because that will give a better understanding. That is the only request that is for among you that.
But then there's one problem with regard to that, my lord. There could be overlapping. There could be overlapping, my lord. Therefore, we would humbly request that your lordships may hear us one after the other. And therefore, my lord, when
Compartmentalization will there be.
issue.
One thing, my lord, there is a point in Article 26 that needs elaboration. The concept of a denomination.
We are not on merits. Let me start on merits.
One second, Solicitor. Now, the point here is that is strictly speaking not in the points of reference.
Yes, yes.
It is there, very much.
For your lordships. Because, my lord, in Sabarimala, that's precisely what happened. If denomination is very narrowly defined, a large number of institutions will just go out of the lordship's purview.
Dr. Dhawan, question number 3 will take care of it.
Yes.
Number 3 is
It
there.
is there, it is.
Number 3 is very much there.
To highlight in the beginning, because this is something that your lordship might take under consideration.
Question number
My lord.
3 probably.
Yes, sir.
will take.
They cover, they cover
Does
that.
cover it.
My lord,
So we can start now.
Yeah.
Whether-
Yes.
anybody start? My lord, yes. We supporting the petition, but my name is included.
Dr. Radhakrishnan, you have a very loud voice. What happened to it? We can't hear you. You need a.
My lord, if your lordship could just give one clarity, I'm in respectful agreement with everything that's been said by this court.
You finish, please. This is with respect to the list prepared by the Nodal
It's a
Council.
Wrong list, he is on this side. That's
Yes,
what-
yes, that's what, and I may be allotted appropriate time.
No,
And
no, it doesn't matter. Don't go by that. That's a ministerial exercise. So it's not that. Don't go by that.
yes, I want to
Our
point
ar-
out that aspect.
While arguing this side, you can support them. While arguing from this side, you can support them. For us, there is.
No, my lord. No, my lord, I am the first.
I may have to give rejoinder.
That's it.
My lord, I moved the review petition. I was the first. My lords, I was the first person to move the review petition. My lords, I was the first person to move the review petition. My lord, at least give me some time at the end of the hearing, at least.
Yes,
My lord, may I just,
So, my lord, now all juniors have become seniors. My name is not included. Give me as 10 minutes at the end of the board. If it is given at the beginning, I'll be greatly obliged.
my lord, may I just seek a clarification? My lord, I do respectfully agree with everything this court has said and we'll abide by that discipline. There is only one clarification we would like. My lord, the review petitions will not be heard. That is my understanding. Because if we have to address you on the review petitions, my lord, my first submission will be review doesn't lie. But my understanding is your lordship will not get into those issues. And only decides the questions of law. Therefore, the review petitions will be decided later.
absolutely right.
The lordships are not deciding.
There will be no mandamus on the earlier judgment of this court, which is in full force and effect. That judgment has not been stayed. So we are happy to address you on questions of law, my lord, which have been framed without interfering with any judgment of this court already delivered. Is my understanding correct, my lord? Your lordship will send the review petitions for hearing to another bench.
The fate of review petition on merits will depend upon how the 9 questions.
That's correct,
are.
my lord. That's what your
The
lordship.
judgment is one rendered per incuriam, sub silentio, void, without hearing the people of this country. Res inter alios acta, altori, nosori, non debet.
Because, my lord, each
Res inter alios acta, altori, nosori, non debet. This judgment was rendered behind the back of these people. And this has resulted in this waste of so much of court's time. My ordinary petitions are dismissed in 93 seconds.
Stop him, Mellis, but anyway, your lordship, Mellis, my suggestion is only this. There are some principal parties, like the Travancore, there was some board, like me, the country here. And of course, central government comes first, that's Mehta. Your lordship on each of the 9 questions may hear them first, because those are the principally affected parties. Here the interveners later,
Correct.
the various other people who are coming
Review
later.
petitions.
I had the privilege of opening the original Sabarimala and the review before Justice Gogoi's bench. But let the settled government open first, then we'll sort out between the three.
Yes, yes, exactly.
My lords,
We are trying to sort it out in such a way.
my lords,
Yes, I think your lordship.
one suggestion, my lords.
Start, otherwise you.
My lords, I.
My lord,
May I suggest this? It is not the Sabarimala review, as your lordship has just now clarified. If your
Can I
lordship
just come to the
says
front?
In that this is a reference in Articles 25, 26, that would solve a lot of which I interpret in the future. It should be seen as one institution lost. We are not looking at that. We are looking at it purely as a question of law. And it will also help, my lords, later when there is reporting.
I think all of us have this broad understanding.
Yes, my lord,
It
if it's formally renamed,
we can-
in Articles 25, 26, that would help.
We'll consider that aspect also.
My lord, I have a.
Arise, please keep this in mind.
If that will arise, we will hear it.
When that arises, you argue that.
When deciding Articles 25, 26, perforce, the Sabarimala judgment will be looked at.
My lord,
No, no.
my lord, I will not say on that.
That Sabarimala judgment will be looked at.
All the judgments should
Saying that can be divorced completely may not be correct. That's
No, no,
all
no,
I
no.
know.
No, my lord, that will take you to the review.
Not on the merits of the review. Right? Your lordships will have to look into the judgment.
My lord, may I submit one thing, my lord? On the questions of law, it will be looked at, not on the review.
Just a minute.
The whole exercise is of enormous waste of public time, judicial time. So much of cases could have been held by this.
My lord, could I make a mention? Apart from all this, this is a different matter.
Our understanding, I think I agree with Ms. Jaising.
My lord.
An organization.
Yeah, normally you are being criticized for what you're saying.
I said, my lord, I would be happy if the PAL business is coming to an end. People come without see, PAL means you come, my lord, none of my rights are infringed.
Nadumpra, your answer can be, my lord, wait for some time, I will keep my own original color.
No, my lord, I am waiting for the end of the board. If your lordship will hear me for 10 minutes, then the bench can be discharged in 1 hour.
Itself has taken longer than 10 minutes.
My lord,
They are all against me. They are all against all designated lawyers are against me. 99% of the ordinary lawyers support
Let me
me.
start, my lord, let me start.
my lord, before my friend can start, my lord, there is my friend.
Time be set apart for interveners, especially those representing multiple different religions. And
What will happen? You have given the timelines from your side. I have also done in consultation my sister and brothers some homework on that. Let us see that how it proceeds. Then accordingly we will keep on requesting you.
My lord, I have an urgent mentioning which has got nothing to do with all this.
Oh,
If your lordship, this is a matter which requires serious concern. There is a rape and murder of a 4-year-old child in PS Ghaziabad. Interestingly, though the post-mortem shows aggravated assault, sexual assault, there is no investigation which is directed towards rape. Only an FIR in relation to 302, that too after great persuasion, has been registered. This requires consideration, my lord.
who is the petitioner?
The
parent?
petitioner happens to be the father. The father.
No, who is this?
The father of the child. The father of the child is the petitioner. This way things go on, my lord. No child is safe.
You want to be listed tomorrow? You want to be listed on
Yes, my
Friday?
lord, tomorrow. Tomorrow, day after, whenever your lordship thinks it's appropriate, but it needs urgent hearing.
You will give you choice if you want tomorrow or on Friday.
What is the prayer?
Friday.
What is the prayer? Listen to me. What is the prayer?
I am seeking transfer of investigations, my lord. There is no investigation which has happened.
Keep it.
That we will consider on merits. But
Yes.
still is the matter.
Your lordship will have to hear me on merits. I will show to you how things are going on.
We'll have to hear you and then only pass. on.
Yes, yes, yes. Friday, my lord.
Right.
Very well.
Mr. Rehear, tell your junior to make sure that if defects, if any, that is cured.
It'll be cured.
Even if there is, we are listing it on.
Very well. I'm sorry to hold you all up, my lord.
My lord, please have a look at, my lord, my volume, my lord. This is thicker because extractions are there, but your lord did not have to go through the judgments.
They are using electronic copies.
No, I'm on. You're sitting there, right? I need you. So if you can sit there, if you don't. So nice of you, sir. You.
Right.
Lord, please come to page 1. Lord, there is something important, my lord, which makes our job a little more responsible, my lord. Lord, your lordships have page 1. Lord, why this is important and why our job is more responsible. It's not, my lord, the one particular aspect centric matter. My lord, please, when the court was, my lord, court has referred the matter to 9 honorable judges. It was, my lord, incidentally authored by Justice Gogoi. Justice Gogoi is the author in Adi Shiva judgment. I'll come to that, my lord, that need not be written. But Adi Shiva judgment takes note of law from Sirur Mutt till that date, and thereafter when this order is passed, the judgment in Sabarimala was also there. Now, keeping that in mind, please have a look, my lord, why we are before your lordships, my lord, and what is, my lord, the scope of this reference. Para 4. It is time that this court should evolve a judicial policy. It's not, my lord, one judgment being right or one judgment being wrong or one practice, etc. Judicial policy befitting to its plenary powers to do substantial and complete justice and for an authoritative enunciation of the constitutional principles by a larger bench of not less than 7 judges. My lord, why 7 honorable judges? Shirur Mutt is 7 judge. The decision of a larger bench would put at rest recurring issues touching upon the rights flowing from Article 25 and 26 of the Constitution of India. It is essential to adhere to judicial discipline and propriety, and more than one, my lord, I am not going into it. Only purpose, my lord, is chair. There is a chair.
But give one chair, please.
No, there is a chair. I was hinting, my lord,
That
only.
one chair give to Mr. Devan.
There is a chair. Yes, yes. Yes. Now, my lord, your lordships will have to adjudicate and interpret broadly 3 terms so far as religion is concerned. Article 25(1), I'll come to that, the text uses the word religion. Second term which is used is Article 25(2), which uses the term religious practices. And Article 26, subarticle B, uses the word to manage affairs relating to religion. Lord, what has happened is, there are, Lord, 3 things which in my submission has happened, and central government is not taking, my lord, one extreme view or the other. I am assisting your lordships what can be the possible way of answering questions and what can be the contours of your lordship's judicial review, which is one of the questions framed. Lord, neither in Sirur Mutt till Lord Sabarimala judgment, my lord, that's the journey of Article 25 and 26. My lord, 3 things are not noticed. A, the Constituent Assembly debates which brought 25 and 26 into existence. B, Lord, the enormity and width of religions in this country. My lord, we are not dealing with, my lord, one religion. The country is having, my lord, a very proud plurality of religions, Hindus, Muslims, Christians, and other my lord, Judaism, etc. But the beautiful part is there is internal plurality in the religions also. Hindu has several sub-denominations. Philosophically, my lord, Hinduism is a way of life. But for constitutional purposes, it is a religion. It is also a denomination. But it is also divided in several denominations. And each denomination has their own independent denomination, which are ultimately referable to the broader concept of Hinduism. No, that is, my lord, possibly not presented so far. Same is about, my lord, the Islam. Now, whatever I have studied about the Islam, my lord, the only difference is that it has one particular holy book where you take guidance from, and one particular originator. My lord, that is Honorable Prophet Muhammad, which is the distinguishing feature. But even in Islam, there is an internal plurality. It's not all Muslims, my lord, which are, my lord, as a one class, one denomination. There are several denominations. When we, my lord, your lordships will have to examine and answer what is denomination. And the same, so we have Shias, we have
They are occupying chairs.
one young lawyer I requested, but he declined. But anyway, you need not.
Lordship, always the edges are respected edges are have me problem. I am in the second line.
I said some seniors are standing.
I am always left my seat, sir. And
All right, sir. Yeah, only, but my answer would be a dignified silence. I requested when Mr.
Not only to you, to everyone.
Sundaresh was standing, I requested him that please give a chair, a very senior member. Anyway, my lord, leave it at that. Any. Lord, the only answer sometimes is the dignified silence. Lord, now, similar is, my lord, Shia Muslims, Sunni Muslims, sub-denominations, etc. And this, my lord, broadly, your lordships are not examining, my lord, theological part of the religion, but must remain in your lordship's mind that Hindu religion is not just Hindus. Islam is not just Islam. Islam has denominations. Christianity has denominations. And this is the beauty of not only pluralistic society in India, but internal plurality, which coexist within the religion also. Lord, just taking 5 minutes of your lordships, Lord, this is what, my lord, your lordships may bear in mind, my lord, while deciding the word religion, religious affairs, and matters pertaining to religion. Lord, there is a reason why religious affairs words are used. Earlier, my lord, it was only religion. But I'll come to that. There is a purpose. For example, during the Constituent Assembly debates, it was only matter pertaining to religion. But one of the honorable members said that some matters are not pertaining to religion, but they are religious practices. And he gave an example of Ganpati Visarjan. That it is a part of Hinduism, broader doctrine. But Ganpatya Sampradaya is a separate denomination. It is not. It may not be a part of Ganpatya Sampradaya, but it is a practice followed since at least 300, 400 years. But kindly have a look at this chart. I will not take more than 5-7 minutes on this point, and I'll switch over to the main points. But this is the width of the term religion, which would, my lord, be a guiding factor for your lordships to decide to what extent whether a Hindu denomination is before your lordships, or a Muslim denomination is before your lordships, or a Christian or any other religion, to what extent your lordships would have the expertise on the subject, and to what level we will be able to assist your lordships, my lord. That is an inherent limitation, my lord, which is subject-specific limitation. Please have a look, my lord. This is, I have given, my lord, for Hindu religion. I have also given, my lord, for other religious, my lord, religions. My lord, as we call Sanatan, my lord, that is Hinduism, we have 4 Vedas. Your lordships are aware: Rigved, Samved, Yajurved, and Atharvaved. It prescribes several things, my lord. Then we have 4 Upvedas, that is Dhanurveda, Gandharva Veda, Ayurveda, and Arthashastra. Arthashastra may deal with only economic aspects, my lord, perhaps. Then we have 6 Vedangas. My lord, this is to preserve and follow the Vedas, which are Shiksha, Vyakaran, Chandas, Niruktas, Jyotisha, and Kalpa. Now we have 4 Upangas. My lord, one is Dharma Shastra. My lord, Yagnavalkya and Parashar, my lord, immediately came to my mind, my lord. But Patanjali also can be, my lord, added in this category as per my limited understanding. Then we have Puranas. We have 18 Mahapuranas, 18 Up-Puranas, Ramayana and Mahabharata. Then we have Mimamsa and Nyaya Shastras. Now please turn the page over. It goes further. Mimamsa and Nyaya Shastra, my lord, which ultimately finds its roots in Vedas, my lord, has 6 components, and these are recognized components. My lord, Nyaya, Vaishalika, Sankhya, Yoga, Purva Mimamsa, and Uttar Vimamsa. Correct, my lord? Kindly mark, my lord, what I have said. This is Astik Darshan. My lord, because there is one beauty in this religion. You can be Nastik. You can be a non-believer. You can be an atheist. You can be an agnostic and still be a Hindu. I'll come to that, my lord, for 2 minutes only. Now, my lord, we have Uttar Mimamsa mein Upanishads, Bhagavad Sutra, and Bhagavad Gita. Now, Agamas. My lord, Agamas are the only things which are referred to by Justice Mukherjee, my lord, my lord, Justice Venkataswamy in Devaru. My lord, above that, nothing is, my lord, discussed. Therefore, my lord, I am pointing this out. My lord, 6 Agamas. We have Shakta, Shakti Sampradaya, my lord, those who believe in Shakti. We have Shaivites. We have Vaishnavites. Then Ganpatya Sampradaya. The Lord Ganesh, Vignaharta, is the deity, is the Ishtadev. Then Kumara, that is Kartik Swami or Lord Murugan. Or Saurya, that is Swami, my lord, it should not be Swami Narayan, it's a typo. It should be Surya Narayan, my lord, it's sun god. It's a, my lord, autocorrect mistake. Kindly correct it, my lord. It is Surya Narayan.
Difference between the two.
Yeah, yes, your lord, ladyship is absolutely right, my lord. And last, and according to me, my personal belief, one of the most beautiful part of this is Nastik Darshans. Nastik means non-believer. They don't believe in God. They don't believe in existence of any superpower. And my lord, when I was studying this long back, not for this matter, I was really surprised and I felt proud that Charvak Darshan is dating, my lord, few thousand years, where the world did not have the concept of religion. And Charvak Darshan, in those days, is the first atheist of the world. He did not believe in God. He did not believe in any superpower. He said there is no destiny, there is no person or a body or a power or anything which controls your destiny. The moment, the way a tree exists, a human exists. The tree is destroyed, the human is dead. Nothing happens, no karma, no afterlife, nothing. And there was his following. Charvak had his own following. Charvak Sanhita is still followed by several. Then second is Jaina Darshan. Jain Darshan and Buddha Darshan also, they do not believe in God. Both Jainism and Buddhism, they do not believe in God. They do not believe in afterlife. I'm not, my lord, giving a theological, my lord, background, but this would be necessary. Now, my lord, please have a look at.
Just Mr. Tushar, if you say the Jain and the Buddhists don't believe in afterlife, then where the Tirthankars one after the other reincarnate? There is a belief.
No, Gnostics don't believe one after the other.
No, Jain and Buddhism, you said. You said they don't believe God, but it ends with the death. That's sudden. But they are these Tirthankars in Jains, it says that they are reincarnation.
Well, that is exactly the difficulty, because neither I am competent nor your lordships would be able to know. In Buddhism, what they believe is salvation, moksha. That you are dead, you are liberated. There is no afterlife. That's what I say. There is no afterlife. They don't believe in idol worship.
Probably Charvak here in my brother is giving that example, Rutampi Beg, but he will
We identify pursuit of happiness to John Locke.
but it actually relates to Charbak, where Charbak says, Jivat, Jitam Jivat, Sukham Jivet, Rinam Kritak, Kritam Pibat.
Yes, but very popular.
So long as I live with material happiness. Even I will be in debt.
I'll
to
consume
achieve
ghee.
The material happiness. So pursuit of happiness in the American Constitution, in fact, relates to
Charvak.
Much.
He says whatever is there is in this world. These are all material things you enjoy.
Yes.
Your Lordship are right. Even if you have to incur debt, you incur debt but consume ghee. Ghee means consume all which is
material pleasure.
Material pleasure.
So I will go into debt, which spiritually is impure, to achieve the material pleasures of existence.
Material life. Yes.
So it's an existential theology.
Yes.
And we do not require John Locke to remind us.
To mind, yes.
This is Charvaka.
It is the Charvak, my lord, some few thousand years back. My lord, answering my lord's question, my lord, they do not believe in afterlife means, my lord, some denominations of Hindu believe that this is only a body. What is the soul is eternal and it only changes the body. From one body, it goes to another body. In Buddhism, there is a concept of nirvana. Nirvana or Mahanirvana means once you're dead, you achieve salvation. You literally achieve liberation. You don't reborn. You are not reborn. You don't get a rebirth. Well, that is the concept I'm saying. But that is a non-idol worship, my lord. Lord, I just, my lord, hurriedly conclude this. Thereafter, my lord, comes, my lord, one of the most visionary, my lord, saint who, my lord, walked on this earth. That is, my lord, Adi Shankaracharya. Taking into consideration all this, my lord, denominations and non-denominations, he codified Hinduism or Sanatana as we call in 10 different sections, which is called Dashanam. Dash means 10, Nam means names. And my lord, what is Dashanam? One is, for example, I'll just give one example, Tirth. Lord, Tirth is one section of that Dashanam. They would have a separate name. If I become a Dikshit in Dashanam Sampradaya with Tirth, then my name would be so-and-so Tirth. You can find out from the name of the saint that he belongs to Giri Sampradaya, Tirth Sampradaya, Bharti Sampradaya, etc., etc. Everyone would have a different tilak. So you identify that he belongs to Dashanam and this particular category. Everyone would have a different salutation for each other. The moment he says Alakh Niranjan, you find out which one of the categories he belongs to. But these are 9 categories. 10th category is in what our legal parlance we say residuary entry. Those who do not fall or do not wish to fall in 1 to 9 would be Hindus under the 10th category. It includes non-believers. It includes those who believe in books. For example, Sikhism. Those who do not believe in idol worship and those who do not believe in anything. So I can be a non-believer, non-idol worshipper, and I believe in Charvak theory, but I can still be a Hindu. Lord, this is the broadness of any religion. Lord, your lordships will have to keep in mind. Lord, immediately, my lord, my lord, I'm not, my lord, getting into beyond a point, my lord, but please have a look at, my lord. This is the, my lord, same thing with, my lord, Islam, my lord, that is, and, my lord, the main 5 elements are saying, my lord, zakat, etc. My lords would be aware. The holy book is Quran, and Prophet Muhammad is the last prophet, my lord. And my lord, but based upon the doctrinal differences, my lord, page 155, I have given, as per my understanding, these are the denominations which are within one denomination called Islam. But they are all Islam denominations. 155, my lord.
This compiling.
PDF 158, my lord, if your lordships are having PDF 158. I'm not, my lord, taking your lordships through this in detail, but Islam, the holy book Quran, then Sunni, Shia, and Khawarij. My lord, Khawarij is now not, my lord, much
stable.
Yes, yes, yes. But your lordships need not go in detail into this. My purpose of showing is that let us not take Hinduism, Islam or Christianity as one particular broad denomination and then take decisions whether it would be a religious practice, whether it is a religion, whether these are affairs pertaining to religion. And therefore, my lord, in section 26B, the framers of the constitution, my apologies, I'm not a constitutional lawyer. Article 26B, they have specifically added not only religious affair, any section thereof. So I need, my lord, I'll give you the broadly, my lord, the why section thereof. Kindly have a look at, my lord, the constitution. And there is a purpose and, my lord, a vision of the visionary constitutional framers, my lord. Why as the word section thereof is used. Lord, 26, the first part, my lord. Subject to public order,
Where are you referring?
so I'm reading Article 26, my lord. And I'll give the reason, my lord, why our constitutional framers were visionaries and why this expression was specifically added subsequently. Freedom to manage religious affairs. Subject to public order, morality and health, every religious denomination or any section thereof. Well, what is the purpose? I'll come to that, my lord, in a detail little later. What is the purpose? My lord, suppose, take for example, my lord, Shirdi. Hindus go, Muslims go, all denominations of Hindus go, Shaivites go, Shakti Sampradaya goes, everyone goes. So it is not confined to one particular denomination. It is section of denomination. Well, for example, Tirupati Balaji. One can say it is a Vaishnavite shrine. One can say it is not a Vaishnavite sign. It is a Hindu sign. As Sabarimala says that all are Hindus, all who go are Hindus. So we cannot recognize any denomination. My lord, I'm not arguing that, but Sabarimala does not even consider or refer to the word section thereof. That's a matter of argument at the time of, my lord, review. So, my lord, section thereof, my lord, for example, Khwaja Moinuddin Chishti Dargah. Hindus go, all communities go. Which denomination you will, we will put it, my lord, if there is some question arises. It would be a denomination because it is a part of section of one larger denomination. Khwaja Nizamuddin Aulia. Everyone goes. So there are, my lord, reasons, my lord, why we cannot blindly and reverentially adopt American doctrines or foreign doctrines, because our religious structure is differently plural, and internal plurality, which gives beauty to it, my lord, has a totally different dimension. And therefore, we did not lift the religious freedom either from the First Amendment of American Constitution or any other constitution. Our framers, though they have adopted some provision in some other articles, 25 and 26 are designed to suit Indian condition.
But Mr. Solicitor, 25, 26 is an import from the Constitution of
Ireland, yes.
Article 44.
Yes, my lord. But, my lord, it is made or tailored in peculiar Indian situations. It's not word by word saying. That's what, my lord, Dr. Ambedkar also says, that it is derived from in Constitution of Ayr, which is Ireland. But Ireland was a theology.
That history of being uniquely Catholic in a Protestant monarch.
Yes.
Or an Anglican monarch.
An Anglican, which, my lord, they used to oppose, and there was rebellions and revolts and etc., etc. So, my lord, and similar, my lord, Christianity, I'm not, my lord, going into it because this is not what your lordships would be essentially. My lord, Buddhism also, my lord, please come to page 160, which is, my lord, the PDF page. 160, my lord, 3. I just want your lordships to see the chart that Buddhism is not, my lord, one denomination. That's the, my lord, possibly our lack of assistance, that in all earlier judgments, we never, my lord, pointed out that this is the internal plurality within one religion. So your lordship's view also will have to be, my lord, suitably examined. My lord, Buddha's teachings, that starts, my lord. Then oral traditions, 18 schools were developed. First notion of Mahayana Buddhism, my lord, etc. etc. My lord, Chinese Buddhism is different. Then Vajrayana Buddhism, my lord, which traveled from India, my lord, which is now being practiced, essentially Mahayana and Vajrayana in Bhutan, Ladakh, Sikkim, etc. My lord, that's not the purest form of Buddhism as Lord Buddha preached. It has, my lord, some element of Ma Tara.
Tantricism.
Yes.
It's a hybrid between Tantricism
Tantrism.
and
It is, my lord, Shaiva Tantrism. The Muni Padma Sambhava in 8th century made a fusion of Buddhism and Shaiva Tantrism, and that is the form of Buddhism which is, my lord, in vogue in Tibet, Bhutan, Sikkim, and other, my lord, areas. So there is an internal plurality, my lord. That's all I am trying to, my lord. Then Vajrayana also, my lord, which has, my lord, next page, my lord, I have given several branches. And, my lord, Christianity, with whatever limited, my lord, understanding I could gather, my lord, because these are general things, my lord, and I have done my own research only to show it is not one thing to say I am dealing with Christianity as a religion. Your lordships will have to decide several things, and the question would be, would the court have the necessary expertise to go into those questions? Your lordships may bear in mind, in most of the cases which we cite for the findings recorded or the ratio, but all those cases came from civil suits. Whether, most of them, whether religious practices, it is a long religion practice, etc., etc. So, my lord, this is early Christian church, Eastern Orthodoxy, Roman Catholicism, Protestantism, and, my lord, there are some, my lord, sub denominations within one larger denomination. So, my lord, kindly bear this in mind. My lord, in India also, my lord, at page 170, which is, my lord, at 173, I have given, my lord, Indian Christianity also, my lord, year-wise, how, my lord, they have separate denomination. The doctrinal beliefs are same. And one holy book, my lord, that is Bible, that is common. The founder is common, but doctrinal differences, principled differences, etc., interpretative differences also maybe, my lord, a worldly word, my lord. It's not difference, but another way of looking at the same thing. And that is how, my lord, this plural, internally plural religious practices, my lord, develop. Now, my lord, coming back to the main matter now, please have a look at, my lord, something which, my lord, in my respectful submission, subject to being corrected, is missed. My lord, when we interpret Article 25 and 26, which can never interpreted without looking at the preamble. Your lordships have always interpreted fundamental rights in light of the preamble. My lord, at least the judgments which I could see, and I would place some paragraphs, my lord, this part is not specifically noted. Please have a look at page 5, which would be, my lord, 8, my lord, PDF 8. I'm just, my lord, your lordships have read and reread preamble several times, but in this context, only one right, my lord, what we have given to ourselves. My lord, I have highlighted in red color. Your lordships have in red color, my lord. Liberty of thought, we are not concerned possibly. Expression, it can be 19(1)(a) expression or expressing religious belief also, because if we go by egestem generis, expression, belief, faith, and worship. This is what is ensured in the preamble. My lord, your lordships may consider, my lord, requiring Article 25 and 26 be interpreted, keeping in mind the faith and belief also. Because there can be several things which are capable of belief system. It may not be emanating, my lord, as a, this is necessary because of the unnecessary doctrine of essential religious practice being introduced. How do you decide? It's a matter of faith. It's a matter of belief. Whether this is essential or this is not essential, you will have to first examine and make a judicial review of religious scriptures. You will have to understand the religious scripture the way it is meant to be understood, which is impossible, my lord, unless we achieve that level of spiritual supremacy. We will also not be in a position to assist what exactly Prophet Muhammad said, or for that matter, my lord, Lord Jesus said, or my lord, the Veda says, or Upanishad says, other things they will say. And based on that, my lord, there can be a faith and belief system which has developed, which is not otherwise contrary to public order, morality, health. And part 3. Then how would your lordships examine the essentiality of that? So that's the purpose, my lord. Now, my lord, coming to how, my lord, the 25 and 26 was framed. And I'll be citing this, my lord, so that it's, I'll have to show the route, my lord, because this was not shown, my lord, earlier to earlier benches, or maybe it has missed or whatever, my lord, I'll not. My lord, the first part is what happened prior to the Constituent Assembly set to debate the draft constitution placed before it. My lord, before that also there were proceedings, there were committees, committees on minorities, committees on religious freedoms, etc., my lord. These are, my lord, also this is, my lord, pre-Constituent Assembly debates, deliberations on 25 and 26. I have confined it to 25 and 26. For completeness, I have placed everything, but I have marked, my lord, what is not to be read because it is irrelevant for the questions to be answered. Now, kindly see at page 10, my lord, PDF 13. This is how, my lord, the first draft was placed by Kanhaiya Munshi. No, the 3 comes there, the subsequent.
It was taken up earlier.
Please, religious and cultural freedom. They are discussing 25 to 30. We are not concerned with anything other than 25 and 26. All citizens are equally entitled to freedom of conscience and to the right freely to profess and practice religion in a manner compatible with public order. I'm sorry, page 10 and page 13, my lord, if it is PDF. Printed page 10.
That's it.
Yes. All citizens are equally entitled to freedom of conscience and the right freely to profess and practice religion in a manner compatible with public order, morality, or health, provided that economic, financial, or political activities associated with religious worship, please underline this, religious worship was the word initially, shall not be deemed to be included in the right to profess or practice religion. Your lordships might, the word propagate is not there. Something turns on that. Therefore, my lord, I am pointing out at this stage. Then, my lord, 2, your lordships can skip. Citizens belonging to national minorities in a state, whether based on religion or language, have equal rights with other citizens in forming, controlling, administering at their own expense, charitable, religious, please mark, this goes ultimately, my lord, in 29 and 30. There cannot be any educational institution of either a linguistic minority or a religious minority, which is educational religious institution. Nothing turns on that for these questions, but I'm just, my lord, pointing out because one of us, my lord, is going to raise possibly the question that 25, 26 applies to educational institutions also. and social institutions, schools and other educational institutions with the free use of their language and practice of their religion. Then no person may be compelled to pay taxes. Well, this becomes Article 27, we are not concerned. Religious instruction shall not be compulsory. This becomes Article 28 in a different format, but we are not concerned. Then no person under the age of 18 shall be free to change his religious persuasion without the permission of his parent or guardian. Conversion from one religion to another brought about by coercion, undue influence, or offering of material inducement is prohibited and is punishable by the law of the union. Please turn the page over, my lord. Then, my lord, Article 2, my lord, there is some. Dr. B.R. Ambedkar independently circulated a memorandum. I have said that. There were 3 drafts, but period, I have said. I'm not as conversant as you, but I have said it subsequently. Yes. Yeah. No, continuously I am overhearing you. Dr. B.R. Ambedkar independently circulated a memorandum and draft article. My lord, his draft article was like this. The state shall guarantee to every Indian citizen liberty of conscience and the free exercise of his religion, including the right to profess, to preach, and to convert within the limits compatible with public order and morality. My lord, this was the draft suggested by Dr. Ambedkar. My lord, now please see, my lord, Rajkumari Amrit Kaur and Dr. Hansa Mehta, my lord, 2 eminent lady members. My lord. India, my lord, has always not only, my lord, treated ladies equally, they have always been treated at a higher pedestal. My lord, there are several judgments of the recent past where, my lord, there is a concept of patriarchal society, or my lord, there is some gender stereotypes, etc. They were never there. We are the only generation, arguably, we are the only, my lord, Indian society, we worship ladies. The President of India to the Prime Minister of India to the judges of the Supreme Court, we bow down before our lady deities, my lord. So let us not introduce those concepts of patriarchy and, my lord, gender stereotypes, etc. There has never been. So, my lord, these 2 eminent ladies, Rajkumari Amrit Kaur, my lord, who became the first health minister in Pandit Nehru's cabinet, my lord, they raised.
Call them the founding mothers.
Founding mothers.
We always say founding fathers.
Yes.
Of the constitution. So let us call these 15 women.
Yes, my lord, founding mothers of the constitution.
Yes.
Correct. Now, my lord, they had pointed out a correct problem.
Yes. These 15 women.
Yes. It's biographical narration.
Participation in the committees.
Committee also.
In the assemblies, their contribution and how some of the articles, especially Article 15(3).
And, my lord, even 25-23. My lord, their objection was, apropos your ladyship's, my lord, very right and pertinent observation. Their objection was that if you say right of religion, some religion forbids what otherwise our social reformers have prohibited. For example, somebody may say sati pratha is a part of the religion. Somebody may say child marriage is a part of religion. So he said that you will be nullifying all reformist actions which have been successful by way of laws preventing all this. That was, my lord, a very pertinent objection raised by Rajkumari Amrit Kaur. And, my lord, she says, Article so-and-so of Mr. Munshi's draft was Lord, kindly now turn to page 13. Your PDF page would be 16. My lord, I'm just making a reference, nothing turns on that for the questions. But Sardar Harnam Singh said that you specifically clarify that right to carry a kirpan is a part of our religion, which was accepted. Now, that's what, my lord, I have said. Then 27th of March 47, the subcommittee accepted Munshi's formulation of anti-conversion clause, which was clause 7. My lord, same thing which I read, my lord, was accepted. Then, my lord, 31st of March 47, as I pointed out, Rajkumari Amrit Kaur, on behalf of herself and Mrs. Hansa Mehta, wrote to B.N. Rao, my lord, who prepared the first draft. It was Sir B.N. Rao, my lord, dear lordships are aware. Emphasizing that many oppressive practices, that is child marriage, polygamy, untouchability, are justified in the name of religion. They proposed narrowing the right of freedom of religious worship rather than broader practice of religion. My lord, therefore, my lord, she suggested that we should have not have religion, but some other word may be used so that earlier wrong practices may not come back. Your lordships can skip that. My lord, please come to page 14, next page, my lord. First conjoined draft report of the Subcommittee on Fundamental Rights was published. It contained clause 16 and 23 on religious freedoms, including right to profess and practice religion, subject to order, morality, and health. Kindly mark, propagate was not there. It was only practice and profess. Rights of religious denomination to manage affairs and own property, prohibition on compulsory religious taxes, anti-conversion clauses, that is 22 and so and so. My lord, then see, my lord, 16 is what is 25 today. That's the only thing which needs to be seen, my lord, on this page. All persons are equally entitled. Please see, my lord. These words are introduced for the first time. Now, kindly pause here for a moment. Why am I insisting or emphasizing on this? Lord, Sabarimala judgment reads that equally entitled includes gender equality. My submission is going to be on interpretation. Gender equality is already taken care of in Article 14 and 15. They are equally entitled. For them, it need not be repeated. Why they are saying equally entitled? The framers were aware that we are dealing with a pluralistic society. And my lord, there is a discussion that one religion may not claim better rights than the other merely based upon the numerical strength. And your lordships would also bear in mind, my lord, the date is 3rd of April 1947, where, my lord, the partition process had started, communal riots were taking place, and the framers of the constitution were aware about the concern that one religion may, based upon the their numerical strength, might try to get something more than the other religions. And therefore, they added the word equally entitled. It has nothing to do with gender. It has something to do only and only with religious plurality of the country, accepting the situation prevailing on that day. Now, my lord, further.
Equally entitled to freedom of conscience.
Yes. So, my lord, everything, my lord, man and women, both are equally entitled to all fundamental rights, which is taken care of in 14 and 15. You need not repeat it. And therefore, it is not repetition on gender basis. It is introduced as a religious freedom so that one religion may not take or may not understand it to have been given more rights than another religion.
No religion is superior than the other.
Than the other, no religion is subservient. All are equal. It is, my lord, manifestation of secularism. It has nothing to do with gender. All persons are equally entitled to freedom of conscience and the right freely to profess and practice religion, subject to public order, morality, or health, and to other provisions of this chapter. This also comes for the first time. But propagate word has so far not come. Now see the explanation 2. One is regarding kirpan. We are not concerned. 2. No person, The right to profess and practice religion shall not include any economic, financial, political, or other secular activities that may be associated with religious worship. So, worship word continues, my lord. Earlier, my lord, what was used was religion. I'm sorry, religious worship, which was objected to by Rajkumari Amrit Kaur and Hansa Mehta, but it continued, my lord, which is subsequently, my lord, changed. I'll come to know.
The word worship is there in the preamble also.
Yes, yes, it is there. It is there, my lord. But in the fundamental rights, the objection was this, that if you say religious worship, some of the reforms which we have made might get nullified, because Constitution was being framed as the stage where there were statutory laws prohibiting sati. Sharda Act was, my lord, against child marriage restraint, etc., my lord. So they would refer to Sarda Act also. The Sarda Act is, my lord, the name of the act, my lord, based upon the proponent of that act, my lord. But it was Child Marriage Restraint Act. And their concern was genuine, but which is taken care of, my lord, subsequently. My lord, now please see page, my lord, 17, the PDF 20, 10.4.47. Earlier, your lordships have noticed state's power to make a law for social reform was not there. It was only subject to public order, morality, and health, and other provisions of this part. So it was kind of an unqualified right given. Lord, yes, my lord, 8.4.47. Constitutional advice, my lord, yeah, that your lordships can skip 14.4.47. Kindly come to the next date. Aladi Krishna Swami Iyer wrote another letter specifically suggesting a clause empowering the state to enact social welfare legislation as suggested by Rajkumari Amrit Kaur and Mrs. Hansa Mehta. The relevant extract is reproduced here and there. Incidentally, Mrs. Hansa Mehta was the wife of first Chief Minister of independent Gujarat when Gujarat was separated, but she was a leader and an intellectual in her own right. She was there in the Constituent Assembly not because she was wife of Jivraj Mehta. Then, my lord, kindly see the bold part.
She has spoken extensively on how a governor should perform under the constitution.
Yes, my lord. That is where, my lord, the word constitutional morality came. Constitutional morality is a I'll come to that. It's a separate chapter. It's a political doctrine as to how government, constitutional functionaries, they should behave, function, work. When there is constitutional silence, then there are certain constitutional conventions. And that convention is known as constitutional morality. Well, subsequently, in the recent years, well, constitutional morality left that meaning and became a standard of judicial review, which I'll, my lord, come to that, which was never conceived. Constitutional morality means this. It's how the constitutionally functionaries should function. And there is a material available that this is how they understood. Dr. Ambedkar also understood it in that context only. The famous speech which is being cited for constitutional morality. To meet the point and then the suggestion is this. To meet the point, an explanation or proviso to the following effect may be added. My lord, now the suggestion of the Honorable two ladies, my lord, the right to profess and practice religion shall not preclude the legislature from enacting laws of social betterment and of the people. My lord, the wordings change, the spirit, my lord, continued thereafter. My lord, now it is something else. That becomes, my lord, Article 25 to 2, B particularly. Then your lordships may come to, my lord, next page, 16.4.47. I am skipping everything which is not relevant, my lord, for your lordship's consideration. And therefore, my lord, I am trying to meet with the report issued with revised clauses on religious freedoms. Clause 16 now guaranteed freedom of conscience, freedom of religious worship, and freedom to profess religion with a significant narrowing from the earlier practice. Clause 17 to 22 addressed denominational rights, religious texts, etc., etc., my lord. Now, my lord, it becomes religious worship, my lord. Correct, my lords? I'm not reading it, my lord. It's only a transient provision which ultimately, my lord, went into some changes. Please come to page 19, my lord, PDF page 22. Lord, this is only, my lord, to complete this. Lord, there were discussions that conversion should be permitted as a fundamental right, and therefore the word propagate should be added. This is what, my lord, it says. Subcommittee of minorities was formed with Dr. H.C. Mukherjee as the chairman. Mr. Ruthnaswamy pointed out that Christianity and Islam are essentially proselytizing religions, and the clauses should permit them to propagate them. Proselytizing means having the idea of converting people. That was one individual view before the committee. Dr. S.P. Mukherjee noted that the right to build places, we are not concerned, my lord. And then your lordship can, my lord, kindly come to next page, 18,447. Now, my lord, there is a change. The word propagate is introduced in the draft. All persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion subject to public order, morality, or health, and to other provisions of this chapter. And that explanation to the words religious worship, religious practice should be substituted. Then, my lord, rest may not be relevant, my lord. On the bottom is, my lord, recommendation for anti-conversion, etc. My lord, now come to the next page, 21, lord, PDF page 23. The clauses went for discussion and debate before a larger advisory committee to discussion. The discussion accepted the change or to explanation 2 from religious worship to religious practice. Lord, therefore, my lord, the suggestions were again accepted. Chairman Sardar Patel requested Sri Rajgopalachari and Sri S.P. Mukherjee to draft a comprehensive clause allowing the legislature to intervene to reform and regulate secular affairs, only secular affairs. Their proposal was appending a new explanation stating that nothing in this right to practice religion shall debar the state from enabling laws for the purpose of social welfare and reform, and was swiftly approved. That any religion, the state can make a law for the purpose of reform or social welfare. This was approved, my lord. The word propagate was taken up at the instance of Ruthnaswamy. Munshi and Iyer noted it was already covered by free speech guarantee, but G.V. Pant intervened and said, at worst, it is redundant and it may not harm anyone to adopt it. The word was thus included. Then clause 17, several members including Sardar Patel, Ambedkar, Munshi and Rajgopalachari debated whether legislature ought to be allowed to prohibit religious bodies from holding property. Rajgopalachari offered a middle path, retaining the clause but qualifying it with subject to general law. This becomes 26D in a different format, but the same thing, right to own and administer property, but not an unqualified right as per the law. So the state can make the law. The debate of anti-conversion clause 21 and 22 between Sri S.P. Mukherjee, Bakshi Tekchand, Frank Anthony and Ruthnaswamy was settled by Sardar Patel's observation that forced and fraudulent conversion was already an offence under existing statutory law, and the matter was better left to the legislature. My lord, then, please see, my lord, next page, K.M. Munshi. My lord, rest may not assist your lordships on these questions. There was discussion on this in minorities committee. Many things may not be exactly worship, but maybe in the sense practice of that religion. You may have to, for instance, the immersion procession of Ganpati. It is not worship, but practice of religion. If you go to the temple, it is worship. Further than that, it will be practice of religion. See Rajgopalachari. The second difference is the right of propagate. Propagation comes under freedom of expression. There is a sharp difference of opinion on this whether worship alone, whether it may be, should be allowed, or whether practice should be included in our fundamental rights. My lord, it was with a view to whether to widen it or not to widen it. My lord, eventually, my lord, it was widened. My lord, kindly, my lord, turn to the next page 24. Lord, I'm not troubling your lordship. Your lordships have any.
Yes.
But, did I miss the query, my lord?
No.
I'm sorry. My lord, please come to page 24. I'm just, my lord, shuffling this through, my lord, because it may not have direct relevance. We'll read 25 textually, and this is how it is interpreted in the judicial pronouncements. Now, my lord, please come to 27, my lord, instead of this. My lord, the rest, my lord, may not have any. My lord, this is regarding, of course, conversion. My lord, the chairman ultimately, my lord, puts it to vote, and ultimately his decision, somewhere in the 10th or 15th line from the bottom, highlighted part, chairman, I
consider these are
matters to be left to legislation. With the concurrence of the House, clause 21 was deleted, which provided in a fundamental right chapter that conversion should be prohibited. Sardar Patel says this is a matter of legislature. It is already a penal offense. Let us leave it to a legislature. We may take up clause 22. This clause 2 is unnecessary and may be deleted. But please see next page, chairman's final verdict. That was forcible conversion. Forcible conversion is no conversion. We won't recognize it. But ultimately he says that there are laws and there can be a law. There need not be a fundamental right either way. Then kindly come to 29.
There is a difference between propagating religion and forcible conversion.
Converting.
Here, what is protected is propagation of religion.
Yes, not by force or inducement or by coercion, etc. That's exactly, but I didn't read it, but these were the words used by everyone. That if you are converting someone because of force, inducement, threat, coercion, then it's no conversion at all. You can propagate, you can convince someone, you can say this is the better things of my religion, etc. Now, my lord, some questions, my lord, your lordships have framed one question. Why was it opened only for Hindus? Article 25 2b says that all Hindu religious places shall be open. All public religious places of Hindu religion shall be open for all sections. My lord, your lordships would get something, my lord, in this. 1st May 1947. The Constituent Assembly meeting in New Delhi took up Sardar Patel's interim report on fundamental rights. Debate was relatively limited. K.M. Munshi moved to add a specific provision that religious freedom will not prevent laws for throwing open Hindu religious institutions of a public character. I'm reading page 29, PDF 32.
The top.
I'll read again. The Constituent Assembly meeting in New Delhi took up Sardar Patel's interim report on fundamental rights. Debate was relatively limited. K.M. Munshi moved to add a specific provision that religious freedom will not prevent laws for throwing open Hindu religious institutions of a public character to all classes and sections of Hindus, directly targeting exclusion of Dalits and lower caste from the people. But this was the idea, because we unfortunately were living in a society where one particular part of Hindu was not permitted to be a part of the broader Hindu denomination by denying them right to worship. Again, this had nothing to do with gender. We last decade or so, there is a jurisprudence which is developed where every constitutional provision will have to be seen from the lens of gender. All provisions are not. Look, there is no discrimination. 14, all genders are equal. 15, irrespective of sex, all fundamental rights are equal. This was, my lord, that era-specific provision, that if it is a public temple or public religious institution, it should be open for all. We must do away with this untouchability, etc., section within the section, etc., my lord, which was very rightly accepted. I'm highlighting because, Lord, one judgment has said that this is to ensure that even women can enter. Women were entering, my lord, all temples. I'll come to that, my lords. Then, my lord, next page, last part. Why section thereof word was used in the, so far, your lordships have seen Article 25 did not have the word section thereof. It was only religion. Now it comes because K.M. Munshi, my lord, all were visionaries, my lord. Alladi Krishna Swami Iyer, K.M. Munshi, there were many, my lord. If I name, I would be doing injustice to some other people, my lord. But K.M. Munshi, sir, I move an amendment that in clause 14, the word or a section thereof be added between the word denomination and the word shall. It was felt that the use of the term religious denomination may prevent a section of a denomination from being protected. Lord, no judgment has noticed this part. Sabarimala does not notice even the expression section thereof. It says that Sabarimala or Ayyappa Swami is not a denomination at all. That temple is not a denomination because it is a larger part of Hinduism. So no protection under 25-26. Therefore, I gave an example of Ajmer Dargah, where everyone goes. It's a section thereof. In Shirdi, everyone goes. It's a section thereof. In Tirupati Balaji, all Hindus go. Shaivites, Shaktyites, Vaishnavites, everyone goes. But it is a denomination because it takes care of faith and belief of a section of the Hindus. So denomination and a section thereof, that was suggested. And no judgment takes, Lord, at least Sabarimala does not even notice whilst holding that Sabarimala is not a denomination because it is a Hindus also go and Muslims also go. And I can give 50 examples of shrines, places, dargah, where all community people go, or places where, for example, Dwarka, Srinathji, it is essentially a Vaishnavite denomination, but Shaivites also go, Shakta Sampradaya also go, every Sampradaya goes, Malad. So you cannot say that it is ultimately Vaishnav denomination and therefore it would not get the protection of 25 and 26. Therefore the word section thereof. Page 32. Lord, in this court, yes. Exactly. Balaji. Lord, I'm sorry, my lord, if I'm going little. Lord, in case of Dargah committee, my lord, that is Ajmer, the five judges bench of this honorable court did held that it is a denomination and it is rightly held. One of the reasons why it was referred to was this anomaly. That why, how can you, it's a section thereof. Why are you not doing it? The only problem with Dargah committee was, for the first time, it introduces essential religious practice doctrine. And it goes to the extent of saying that not only essential religious practice, your superstition is not protected by 25 and 26. Nobody says superstition should be protected, but who will decide whether it is a religious practice or a superstition? Courts certainly cannot decide. If it is a superstition, I'll give your lordships, I have compiled, my lord, laws which prohibits superstitious acts under Article 25(2)(b, social reform. There are acts, my lord, against black magic, against, my lord, several. I'll give, my lord, the list of laws. So superstition can never be a test for deciding whether it's an essential religious practice. My lord, kindly say practically, if some particular practice comes before your lordships, my lords will have to first decide whether it is a religious practice or not. How can that be decided? You will have to interpret the concerned religious text. Concerned religious text, my lord, would be interpreted by several scholars, my lord, by what we call in, my lord, Hinduism, Bhashya. Bhashya is a commentary, several commentary. If Holy Quran has hadiths, have several other documents, you will have to examine all in juxtaposition and try to understand what is meant when it was written, which is now the sacred text, which is impossible. We also will not be able to assist.
Mehta, are you suggesting that at a certain point of time, at a certain stage, the court may not into the domain of deciding the essentiality, which probably would be a little bit more than the court should be asked upon to interpret?
Lord, I am on a judicial review that this is a domain which may perhaps not fall within the judicial review domain, irrespective of the religion.
There is a difference in the nature of the proceeding in which a question of a religious practice or not an essential religious practice may lie. Don't only see it from the narrow compass of Article 32 or 226. It may be in the form of a civil suit also.
That is one of my submissions. My lord, as I go further, your lordships would find I have not pitched my submission at a higher threshold.
If your proposition is taken to a logical conclusion, then courts are not essentially experts in matters of science, but the Evidence Act empowers the court to examine the opinion of experts and become an expert of experts.
Correct. And take assistance. That's why one of the
33 or 32 customs, usages, practices. There is a provision in which the law permits the court to use objective parameters to come to correct subjective decisions in the facts of each case as to whether it is a long-standing practice, usage or not.
Probably the difference is here. Science is based upon logic and reasoning primarily, where religion is based upon belief.
Faith and belief. There are two answers, and I'll come to that.
We can go into the aspect touching upon belief.
Yes.
With a little understanding, as you rightly said, without
I'm going to, my lord, address little in detail on essential practice. Why I have highlighted is, first, your lordship will have to decide what is religion. Then second, it would be whether it is essential part of the religion, which would be very, very difficult, and if I am permitted to say, difficult to decide. And third, your lordship will have to say whether this needs examination or not. I have devoted one 2-page chapter on this, that even if it is necessary, kindly give me a...
My question is not a opinion in any way. I would just want some...
Understood. No, it's just a...
you enlighten...
Elucidating.
Yes.
What has happened is, my lord,
because there is a difference between an opinion as to faith and the faith perceived. One can have a particular faith, but whether that faith, opinion exists in that denomination or not can be separate from the testing of what is the faith itself.
Lord, I would answer, my lord, when I come to that, but my immediate response is this, that...
Because a religious head says, this is my faith, and the followers abide by that. The fact that this is my faith, stated by the religious head, is something which is within the domain of the court to apply the appropriate forensic criteria or tools to decide. But whether that faith actually exists or not is for the religious head.
Rationality or scientific nature of it cannot be gone into. Lord, that's correct. Lord, that's a correct approach. Lord, what I have suggested, Lord, as I go further, Lord, there are two things that your lordships can decide.
We are fully conscious that when we see Article 25, Article 26, it is an unique capsule which must be seen in contradistinction to fundamental duties of scientific temper.
Correct.
Because there may be a faith in the existence of an all-encompassing, omnipotent power, which the scientific temper or scientific experiments may not divulge or unravel as of now. That may not be a question which courts will ever enter into. But whether such a faith existed amongst the members of a particular denomination or a part of denomination can be a issue framed in a suit between two groups or even intergroups.
I'm fully, my lord, in respectful agreement, but not the question whether it is essential part or not. And second, and my lord, I don't want to jump the gun. There is a separate chapter. If it is found to be by a legally trained mind, either unscientific or illogical, only a minute.
Really relevant at all when we come to faith.
Only a minute, my lord. Your lordship finds, my lord, that this is something unscientific, not palatable or something. The remedy is for the legislature under the social reform.
Social, right.
Second, my lord, I have also devoted one chapter that in case if it is required to be gone into whether this is a religious practice at all, the remedy would be a civil suit where the parties can lead evidence, examine expert witnesses, experts on the subject, which will have the court will have the assistance of those expert witnesses, and based upon the totality of the facts, the court would examine whether this is religion or not. It cannot be that there is nothing in affidavit which satisfies us that this is an essential religious practice. That is done. This is a part of judicial review. Therefore, my lord, I'm not, my lord, for a second saying that 32 or 226 would never apply. I am only on the extent of judicial review.
So we understand your submission is not on justiciability, but the forum at which the
No, justiciability also. And I'll, my lord, make my submission. Yes.
You will make it.
Justiciability also, my lord. That's, my lord. I must make it clear. Lord, it may meet with your lordship's acceptance or not, but justiciability and in most of the cases, the forum also. Suppose, for example, in some religion, some person claims that right of human sacrifice has been a practice in our religion and it is an essential religious practice. He comes before your lordship under 32. No evidence is needed. If some example comes before your lordship which directly hits either public order, health or morality, your lordships would not be required to go into whether it is religious or not, whether it is an essential part or not. And your lordships can say, no, this is contrary to morality. I can have, for example, any, my lord, I don't want to give examples which are immoral examples.
So we take it. So let us take the Sabarimala case. No? Rules are also challenged. There is a forum by which rule can be challenged. So 226, you can always do it. But according to you, if you can reframe what you are saying, the power of judicial review over the constitution of the rule is rather limited according to you.
Yes.
With that action, we can put it.
Yes.
Notwithstanding whether suit is edible, suit also can be filed challenging that.
And it can.
Suit also can be filed.
It can be challenged.
But you can say that court should be civil. Certain areas you can venture into, like competency and other things.
Yes,
legislative competence,
arbitrariness.
But court cannot substitute itself.
Yes.
With the available material, and then how it can't.
And based on affidavits that it is a religion, no religion. It's not a part of religion.
Take
whether
it
is essential or not, that is, my lord, something a second guess which may be done in given circumstances. Suppose cannibalism. Somebody says that cannibalism is a part of my religious practice. It's immoral. Your lordship doesn't need to undertake any theological exercise. Lord, in Pakistan and some other countries, there are, Lord, the courts, what is called, Lord, ecclesiastical courts, which are specially, Lord, constitutionally created courts.
Rather, we can go into the decision-making process, but not on the decision.
Merit review is not permitted. Well, that's what, my lord, my submission. In a different format, I'll make it good. But in, my lord, these courts, which are constitutional federal courts, My lord, the judges are having legal expertise as well as ulemas. They sit together and decide whether it is a part of religious practice and whether, if at all required, it's an essential part of religious practice.
In other words, if there is a social ill which is being branded as a religious practice, the court can certainly distinguish between the two, a social ill or an evil and an essential practice of religion.
My lord, essential practice is a separate issue, but if it is a social evil, the answer can be
Because
yes.
many social evils are given a religious color, but the court can always distinguish it.
Certainly, but but the real answer in law, the constitutional answer would be the remedy, even in case of an evil, would be 25(2)(b,
Yes.
which says for social welfare and reform, the legislature can legislate,
Correct.
and there are legislations which I will show that they are the legislatures are not passing such laws. Well, I'll just not finish this and
Article 25 is a balance between what was existing and what has to be done in future. What has to be done in future is left to the legislature. But the Constitution also tries to preserve what is already existing in Article 25.
I'll go a step further.
One overarching, that is, it is subject to public order, morality and health when it comes to freedom of conscience, propagating
And part 3.
and propagating.
And part 3. In 25, part 3. Correct. My lord, even if there is a the practice which is in vogue at the time the Constitution came into force, even that can be subject matter of 25(2)(b, reform law or for social welfare. Something which may be good for the society or maybe bad for the society and continued can still be reversed by the legislature by preventing it, regulating it, prohibiting it, whichever way the legislative wisdom goes. Now, my lord, kindly come to page 34. I'm just going to quickly run through and come to Malad Sirur Mat. Well, this is conversion. Malad. I'm not reading it. Kindly treat it as read. Malad, ultimately, they say, yes, that send back to the advisory committee, and advisory committee, Malad, comes back and it says that it is an evil, but it is already penalized and it can be penalized. That's all. Now, please come to page 38, my lord. The PDF would be 41. 41. Now, any class or sections of Hindus. Now, please bear these in mind right now when I read 25 and 26. My lord, your lordships may have the background why these were added. That's the purpose. This note is our note. Yes. Well, this is the note which I have said. Well, this is the note of Sir B.N. Rao. Not note, our note, my lord, in our written submission. It's a note part of the debate, of the record. The expression any class of sections of Hindus or class section of Hindus used in subsection B of clause 2 of Article 19 will not prevent the making of any law for throwing open Hindu religious institutions of a public character to all classes and sections of Hindus. There is, however, no objection to the amendment. Discrimination on the ground of caste, etc., is forbidden by Article 9, which is 17 now. But Sabarimala says that all sections of Hindus were introduced so that it is gender specific. But it is not gender specific. As a matter of fact, I'm sorry, but one opinion in Sabarimala says that Article 17 applies to women. You are treating women as untouchables. That's the opinion. One opinion, that's something I have a very, very strong exception to it. Therefore, I am insisting all sections of Hindus had the background of all castes, not gender. My lord, India is not that patriarchal or, my lord, gender stereotype society as the West understands. Sometimes that's the problem. It's, my lord,
Question of untouchability has its own history
yes,
in India, and therefore to get over that, Article 17 was made a fundamental right. Untouchability in the context of the Sabarimala, I don't know how it will be argued.
it can never be justified on untouchability. It can, I'm putting, my lord, that straight.
Speaking as a woman, I can say there can't be 3-day untouchability every month. And on the 4th day, there is no untouchability.
No, I understand. No, I'm not on, my lord, menstrual
Let us
cycle.
go by the hard realities.
My lord, but entry of
One
women,
aspect, the other aspect is the main question.
we fully agree with this.
Speaking as a woman, Article 17 cannot apply for 3 days. And on the 4th day, there is no untouchability.
My lord, I have no issue or dispute with that. Sabarimala, I'll defend in my own different way. Without, my lord, Sabarimala does not mean 4 days. Sabarimala means a particular age group. And let us be very clear, if there is any confusion in anyone's mind, Lord Ayyappan temples throughout the world are open for all sections of ladies, except one particular section, my lord, temple, my lord, which is a sui generis case. Which is a sui generis case. There are 3 temples, Lord Ayyappa temples, my lord, in, to my knowledge, my lord, in New Delhi, all, my lord, right from child till, my lord, old women, everyone goes and worships. It is only one temple. Lord, there can be a denomination and denominational practices which we have to respect. Lord, everything is not relatable to human dignity or individual body freedom. My lord, if I go to a mazar or if I go to, my lord, Gurudwara, if I have to cover my head, I cannot say that where is my dignity? You are taking away my right of choice. This is what Sabarimala says. Your right of choice is taken away. Your autonomy is taken away. It's not taking away of the autonomy. It is respecting the tenets, the faith, the belief of that religion. When we go to, my lord, Ajmer Sharif, we do wear, my lord, we do cover our heads. When we go to a Gurudwara, we do cover our heads. And nobody, my lord, says that this is bodily integrity, my lord, which is, but this is, my lord, has slipped in, my lord. There is a new, my lord, jurisprudence which is developed. My lord, I'll bring your lordship's attention to that. But it's saying this, my lord, all sections of Hindus is meant to mean no caste-based discrimination.
That is the first question, Mr. Solicitor. That is the first question. That 26, preserving the right of religious practice or managing religion by a denomination.
Religion affairs.
Prevails over 25. That is the right of every individual to conscience and to practice. So there is a stratification of 25 and 26 with 26 supervening 25 rights.
Lord, there is divergence of view.
So that is what you are trying to, I'm just trying to formulate what you are trying to respond to the first question.
I'll come to that, but immediate answer is this.
Supervening 25.
No, that's not my, well, therefore I said, I am not raising any of my arguments at a plane, which becomes...
So far you have not raised any argument, you are only...
Yes. It is historical background. But my answer, immediate answer, and I'll finish this. 26B is not a standalone island. It will have to be read with 25. And other parts of the constitution also. Now today, my lord, after Coelho, after, my lord, this TMA Pai, and after R.C. Cooper, we cannot say that any fundamental rights is an island and it cannot take color from any other fundamental right. Article 25 and 26 also will be governed by 14 and 15. That is no gender-based discrimination. I'm not pitching it high. Sabarimala is a sui generis case. On facts, I'll defend.
Interesting difference. 25 makes it expressly subject to other...
I'll come to that.
26 is unshackled.
Unshackled.
26 unshackled.
Yes, that is, my lord, a possible view. My lord, that, but there is a view, my lord, on this side, that it should be a separate island. 26 is unfettered by any provisions.
Putting it that.
I am not putting
You are
it.
not
My lord, it
putting
would be unfair, my lord, to putting it that high, that one article of any fundamental right chapter can be an island and we can do anything, my lord, we want. That's
No,
my lord, my.
not anything. It's subject to moral
Oh, of course, my lord. Yes.
order and
Not
health.
part 3, not part.
Health. Definitely not cannibalism, as you say.
Lord, there are some arguments on our side. There are some arguments on our side which says that 26B cannot be read even with 25(2)B. Even there cannot be any law for social reform or, my lord, which takes away 26B, right? Which, according to me, my lord, is too high, my lord, interpretation, my lord, to be given. Now, my lord, I'm through with, my lord, this. I'm not, ultimately, my lord, it comes to what 25.
Mehta probably will have to also address, because we should not stretch the consideration to a point where we consider all Lord Appa temples in one frame. This has to be specifically with only one. As you said, that all others, this is not the restriction. It is only in one special temple.
That's not, my lord, my submission. My submission is that 25 and 26, as my lords have used the word, is a capsule. It will have to be read together. And 26 also may take color from other fundamental rights. I am saying,
I'm not with what Brother Ramunda said.
I'm only saying Sabarimala is a sui generis specific case. There may be other temples having their temple specific peculiarities.
So this has to be specific to that.
I'm saying Sabarimala, I'm not right now touching. It's a sui generis case, my lord. I'm not saying there may be other temples also, my lord, where there are for example, this is attribute of a deity. In Ayappan Swami case, it's an attribute of a deity. Lord, how would we judicially examine? Can attribute of a deity be ever subject matter of, Lord, a judicial? With that, I'll come to that. Please come to
It's not a mere practice, it is connected to the belief.
faith and belief both.
So it will be a little bit more.
Yes, my lord.
Yes.
Lord, therefore, kindly now come to 25 and 26, and then I'll directly come to Lord Shirur Math. Okay. My lord, 25. First, see, my lord, the title of the chapter, Right to Freedom of Religion.
Also, I give you an answer for European general Islam.
Lord, the subtitle of part 3 is Right to Freedom of Religion. Correct? Now 25. Freedom of conscience and free profession, practice and propagation of religion, subject to public order, morality and health, and to other provisions of this part. Lord, it is specifically made subject to part 3. All persons are equally entitled, equally is a manifestation of secularism, I have said, to freedom of conscience and right freely to profess, practice, and propagate religion. So, first word which is used is religion. Then 2, nothing in this article shall affect the operation of any existing law or prevent, am I with your ladyship, my lords?
Prevent the state from.
Yes, ma'am. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law, A, regulating or restricting any economical, financial, political, or other secular activity which may be associated with religious practice. Now, please see, my lord, this is practice of religion. First is religion. Second is, while you practice the religion, there may be something which is either economical, financial, political, or secular, and that can be regulated or restricted by the state. Now, B, providing for this again, my lord, is a right or negatively couched, my lord, provision that state is not prevented from doing what? providing for social welfare and reform. This is the power specifically conferred. And this, in my submission, is not confined to any religion. Now, second part, or, which is disjunctive, throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. I have already pointed out that is a caste-specific intention being reflected. So, for all religions, there can be a law either providing for social welfare or providing for reform. And all religious places, nobody can say that one particular caste will not be able to enter temple of another caste. Forget 17. I'm taking a little broader vision. There can be a possibility, unless we read it this wise, that one temple of one particular denomination, say X caste of Hindus, may prevent another section of another class of Hindus who are not protected by 17. We will be dividing the society if we read it that way. Therefore, I am not reading.
I didn't get it, not very clear, your submission.
Yes, I'll again point out, I'll make myself clear. I'm explaining why there is a mandate that you can make a law for social welfare and reform for all religions. No dispute. There cannot be any dispute. Why the word used is throwing open of Hindu religious institutions of public character to all classes and sections of Hindus. It has a noble idea. And the interpretation which I am trying to give is that forget those who are covered by 17 scheduled caste persons, who were traditionally earlier not permitted to enter the temple. It is not mentioned in this provision that it is only confined to permitting clause article 17 people. Why? Unless we take that view. Both of us are Hindus. I belong to a particular denomination. He belongs to another denomination. There is a temple of my denomination. He is not covered by 17. He is not a Dalit. Well, let me put it straight. He is not, my lord, a scheduled caste person. But for this, I can prevent him also. There would be division amongst Hindus. There can be a division inter, say, Muslims. That is why Muslims would not come, because this is only for Hindu religious institutions. Unless we give this interpretation, there would be a serious danger and apprehension of society being again divided on caste basis, not, my lord, based on Dalits versus non-Dalits. And power is with the Dalits.
Class and section.
Yes,
Two words there.
Class and sections, my lord. Two words, my lord, to make it very clear that suppose, my lord, there can be more than one category of Dalits. So class is Dalit, but there can be, my lord, other sections, my lord, that Dalits will permit, but a category of Dalits we will not permit. It can be, my lord, different.
Backward class under Article 15(4), socially and educationally backward.
No, my lord, suppose, my lord, we say, it may be, my lord, suppose occupation based. For example, that Dalits are permitted, but those who are doing, my lord, that activity of manual scavenging will not be permitted. Or those who are dealing with leather of the dead animals will not be permitted. Therefore, to be on the safer side, they say that all classes and sections of.
Pointedly, your argument is that class and section cannot mean and include gender.
Gender, yes, ma'am. It's overarching.
Excludes gender.
Why? And I am not saying that means gender can be prohibited. That is.
But this would not.
It's not intended for that. It is intended for the caste situation existing in 1947 when the constitution was framed. The gender equality is already there under 14 and 15, that you cannot discriminate based on sex.
But then the KVPs should be a public character.
Public character.
The institution must be of a public character.
Public character.
It's a private character.
Not. Yes, but there are some private temples. There are private temples in this country, my lord. Therefore, the framers of the constitution have risen from the rank. They have played on Indian streets. They knew the hard realities of life, that what is happening in the society, and they were giving a constitution which deals with all these issues. That there are private temples, public temples, one particular caste is not permitted in some particular temples, etc., etc. And therefore, this was a reformist move specifically by the constitutional makers, leaving rest of the reforms for other communities, including Hindus, other religions, including Hindus, to the state.
The form of assimilation of Hindu society.
Yes.
Because there were deep divisions within Hindu society.
And preventing discrimination. These were, my ladyship is right, these were the two things. Then, my lord, explanation 1, we are not concerned, Kirpans. Then, my lord, 2 also, we are not concerned. It says Hindus include Sikhs, Buddhists, Jains, etc. It's not a question of dispute. Now, see 26. Freedom to manage religious affairs, subject to public order, morality, and health. Well, your lordships are right. It specifically absent, there is a conspicuous absence of textual words, other provisions of this part. So it is capable of reading in two ways, that it is a standalone island provision. It is not shackled or inhibited by anything in either Article 25 or any other fundamental right. Second interpretation, which, my lord, I personally subscribe to and I assist your lordship with, is that 26, in the present day, the way jurisprudence has developed, jurisprudence says that no article in part 3 is an island. It is always to be understood with some other articles of the Constitution, other fundamental rights. That's how what they call harmonious construction. That's what Devaru judgment does.
Yes, you are right.
Thank you. That's what, if the other side, my lord, agrees with me, I immediately am on my alert. There is something seriously wrong in my argument. But yeah.
No, there should be harmony also between all sides here.
But here we are.
No one is island.
No, my lord. Otherwise, this was on a lighter side, because no one here should be arguing for succeeding or losing. We are assisting your lordships to answer questions, and those answers which have large-scale ramifications for decades to come. Therefore, my lord, it has to be, my lord, the assistance, my lord, rather than any adversarial thing. Now, please see, subject to public order, morality, and health, every religious denomination or any section thereof shall have the right, A, to establish and maintain institutions for religious and charitable purposes. Only these two. Earlier, my lord, the term religious, which was used in the then 30, is deleted now. B, to manage its own affairs in the matter of religion. This is, my lord, what is falling for your lordship's consideration. But D also, C and D, your lordship may read, because Sirur Mutt was dealing with D. To own and acquire movable and immovable property, no dispute. To administer such property in accordance with law. So this is, my lord, shackled by one condition, that if there is a law prescribing your administering the property, your right to administer the property would be in accordance with law, if made. Correct, my lord? This is the textual meaning. Now let us, my lord, start with Sirur Mutt. How this is, my lord, considered in Sirur Mutt. The relevant parts, my lord, I have quoted for your lordship.
Solicitor General, in the context of the Sabarimala controversy, how Article 26 is relevant?
My lord, their argument was, I'll just answer. The argument was that it is a denomination. 26, as your ladyship has noticed, is a denominational right.
I didn't agree that it is a denomination, that it applies, that the temple is open to all Hindus and not related to a particular
argument
or something like that.
Lord, argument was that it is a denominational temple and therefore 26 would apply. The court held that it is not a denomination without noting section thereof, saying that it's a Hindu temple ultimately. Section thereof is not. B was placed into service to say that it is the right of this denomination to manage my affairs. And managing the affairs means that there is a faith and belief that particular gender of particular age group would not be permitted. So the court said that first it is not a denomination, and it says that 26B is given an expansive meaning. I'll come to that. I'll
56 does not apply if they held, majority held.
It was not necessary to go into the second question. I agree.
No need of Article 26 being applied.
But they have also.
So to say.
But I'm sorry, but there are 20-30 pages written on Article 17. What is the meaning of Article 17? But I'll come to that, my lord. I have a serious views on, my lord, some of the paragraphs, my lord, and I'll.
We need not go to Sabarimala.
No, we are not going to, not Sabarimala, not
Sabarimala. To understand one. 25 is with the temples, Hindu temples of public character. 26 with the deals with the denomination. Not for there. Only commonality is that both of them will make clear that is they are all subject to public order, morality, and health.
Correct, my lord.
You they travel on the different channels.
No, my lord, I'm not on.
Little bit overlapping.
I'm not on. I'll not argue review on Sabarimala, but the journey of judicial evolution from Sirurmat ends at Sabarimala. So in that process, I'll read Sabarimala. That's all, not for review. This is how there is a shift.
Mr. Solicitor refers to the 9 judgment. There will be 7 questions are there. At least question number 2 and 3, they directly pertain to Article 26 also. Therefore, essentially, arguments will have to come for both sides on 26 also, and probably will have to respond to that.
Correct.
So ultimately, it may or may not have any direct or indirect impact while deciding a particular case. But what is the true meaning and scope and import of that article? Probably that is required to be gone.
May I only add one part with your lordship's permission? When your lordship says that judicial policy will have to be evolved, how to deal with such issues. So I'll have to show, without going into how Sabarimala is right or wrong, that it started with Shirurmat, and this is how the judicial exercise is undertaken for 25-26 in Sabarimala, without giving, my lord, anything that whether it is right or wrong. But I can always read it as a part of the judgment, because the journey starts from Shirurmat and ends at my lord, Sabarimala. Now it would finally end, my lord, by what your lordship decides. Now, my lord, kindly see.
Hopefully.
Yes, my lord. Your lady.
Or a new journey begins.
Yeah, but yes, my lord, that also. Because broadly, there are 3 eras, my lord, of this evolution. First is Justice B.K. Mukherjee era. And Justice B.K. Mukherjee was, apart from being, my lord, a scholarly judge, was also an expert in Hindu law. That was first era. My lord, then comes the second era. That, my lord, where Justice Gajendra Gadkar era. I'm not in any other sense, my lord, just to define. Then third comes Viraswamy era. Justice Ramaswamy era. Some 3 judgments, my lord, with which I'll my lord, show some.
Probably 4 or 5 judges.
With all our 5 judges, Justice Ramaswamy is in 3 or 2 judge combination. And fourth is, my lord, this last decade, my lord, the new jurisprudence which is
Manifest arbitrariness and constitutional morality.
Constitutional morality.
Do we use constitutional morality in interpreting the encapsulation of freedom of religion rights between 25 to 20?
It can never be a test. It can never be a test for judicial review. It is something else.
It's faith versus constitutional morality.
Faith, belief, worship. Constitutional morality is some, I'll not show. Constitutional morality, even this court has not understood as a part of judicial review. It says how governors, prime ministers, president, constitutional functionaries under the constitution have to act. It's a political doctrine. It's not a doctrine for judicial review. And that is how in Keshavanand Bharati it is understood.
This is why, Mr. Solicitor, I was putting the question, what would be the import of the absence of subject to other
my lord, I'll be addressing, my lord, let me.
Of the part 26 and making 25 subject to other processes. Because 17 definitely you have addressed, but there is also 15.
I'm addressing that also.
And therefore, when it is subject to other provisions in 25, subject to 15, equality cannot be taken away on the ground of sex, articulated further into gender.
Even 14.
But 14. But if you see 26, it's not subject to it. We are fully conscious of it being compatible with others, but not subject to it.
Lord,
There is uniqueness in a particular denomination to say this is how our worship is done, or this is how the religion we understand as salvation to our deity. Can that be tested against the paradigm of equality under 14 to 16?
Lord, I have given, my lord, the answer to that. My lord, the answer is that neither 26 is supreme or superior, or 25 is subordinate or dependent, nor others, my lord. And that's how Devaru answers this precise question, that the interpretation will have to be purposive, reading 25 and 26 together. That's, my lord, according to me, is a correct position and law for that purpose, my lord. Can I?
Actually, Article 25 is with regard to, from the preamble, right, freedom of thought, belief.
Faith, belief, and worship.
Thought, faith, belief.
And worship.
Worship is a manifestation of that belief and thought. It is a manifestation. And Article 25 is related to conscience, which is also part of that. But Article 26 is not related to conscience as such. It is only a freedom to manage religious affairs.
The reason is,
Totally different area.
your ladyship is right. The reason is 26 is a denominational right, and denomination cannot have a conscience, but not only individuals have conscience. 25 is for individual or group of individuals, and therefore the word conscience is used. 26 is denomination specific. Lord, now, my lord, I am in three parts. Lord,
Any section thereof.
yes, any section there.
Got some food for thought, so better you answer it after lunch.
After that. Obliged.